So our topic today is looking at high performance court and divorce case triage. It comes from the idea that most courts are interested in trying to find better ways to more effectively handle contentious and often really emotional divorce cases in a way that better meets the needs of the individual families involved. And our little cartoon, and why that's important is divorce is a lot of opportunity, I think, within the divorce cases for this idea of triage or case differentiation, of trying to resolve these cases in a timely way with the appropriate level of court resources directed at them. And in a lot of courts, divorce cases get treated essentially the same way. There is a set of prescribed steps that every case goes through. And that's, in particularly in uncontested cases, those parties might be receiving services that they don't really need and don't really want. They would like to get their case resolved. They've got most of the issues taken care of, they believe, and just need the sign-off of the court to move on with their lives. And so the idea that reduce the burden on those particular parties on the uncontested side is a good thing for them, plus it frees up some additional court resources for those parties who can really benefit from it, and plus sort of reduce all of the workload of the staff and judges who oversee and manage those particular cases. And so this idea that differentiating cases or triage, differentiated case management, sort of similar terms for the idea of devoting the right amount of resources at the right time to get the right sort of outcome for individual cases. And use those resources wisely, because as we know, domestic relations courts, family courts, are never resourced or staffed at the level they should be. And this is a way to help preserve and enhance the quality of those resources. Through the generosity of the State Justice Institute, the National Center received a grant to look into developing a case triage instrument. The idea was to focus primarily on cases that are uncontested and those that have a good opportunity for early resolution. Certainly while the process varies from state to state and court to court, in most instances, divorce cases, there's an initial filing, there's service, and then there's either an answer or there's not. And in all of those early stages, there's a lot of opportunities for triage or for resolving the case in an early fashion that might benefit the parties and might benefit the courts. And so what we'd like to talk about today is we would like to review that instrument, that prototype instrument that was developed as part of this project, and that focus is more on the uncontested area of divorce. We have two other presenters, Deborah and Serpi, who will be discussing application of triage in their particular court and state, and how they've been working to develop a triage approach, and sort of under development in Nebraska, and it's in place in Cuyahoga, so be able to hear a little bit about that. And so, Shannon?
Thank you, Brian. Hi, everyone. Thank you for coming to our session today. So I'm going to talk about the project a little bit and how we came up with the particular instrument we came up with. So as Brian said, we got a grant from SJI, the State Justice Institute, to work with Colorado, Nebraska, and Ohio to develop a tool that courts could use to help triage or at least differentiate their cases. So the committee met first in February 2014, and at this meeting we reviewed many processes and instruments that we could use as examples and see what other jurisdictions are doing throughout the country. One we chose to focus on was one that was done in Holland. Of course, it was done in Holland, so it was all in Dutch. after I learned Dutch, we were able to translate it and see that it was primarily designed for pro se litigants. It is an online tool. The user would go to the website, and at the first page they see, well, what would you like help with? Of course, one of the answers was separation, so that's the one we chose. Now, when they chose separation, they were taken to a series of background questions about their name, address, age, what was their situation, did they have kids. They also had a series of personality questions, at least that's what I refer to them as. And it asked really detailed questions about, do you feel comfortable living alone? Who has more financial support? Do you have kids? Do you feel comfortable taking care of them? Do you want mediation? It was very, very detailed. So based on how they answered the questions, the survey would direct them to some recommendations and referrals and services that were actually in their jurisdiction where they could get help, and it also described the final steps in the legal process. So even if they wanted to get mediation and maybe try to work it out, there were resources for that. Or if they knew that they wanted a divorce, there were resources for that, and also what they could expect when their divorce was final. One thing we really did like about this particular survey is it also put a strong emphasis on domestic violence. Throughout the survey, when I was going through and taking all the different options, questions, it stressed domestic violence, that if there was any indication of it whatsoever, the user should get out of the situation, call the authorities, and then it gave these different resources that the user could go to get help and assistance with domestic violence. After we reviewed that one, we did go through other tools at the meeting, different forms, intake forms. We also had a couple of experts in the field present on their processes that they're doing in their court. So we looked at all of this different stuff and thought about it, and then decided, okay, what are we trying to accomplish here? The purpose of screening is to grant judgment of divorce at the earliest opportunity that best meets the needs of each individual family, while also ensuring parties receive the level of oversight and support necessary for a fair outcome. That was our goal. However, we wanted to decide, how are we going to go about doing this? Do we want to get into a very detailed triage, case differentiation, or what else could we do? So as Brian pointed out earlier, there are those litigants out there who actually know what they want. They've worked out their separation plan. They've worked out custody. They just want to go get the process done, be done with this emotional, stressful time in their life, and not have to go through any kind of mandatory mediation or a 6-month waiting period or a year waiting period or any kind of therapeutic services. They don't want to drag it out. It would just make it worse for them. We decided to focus on this group of individuals because if we could figure out a way to get them through the system very, very quickly, then that would free up court resources to help those families who really need them. So what we came up with is the tool you see here, and you guys also have a copy of this as your handouts because I realize it's probably hard to see on the screen. And of course, the first thing we recommend is just background questions, name, address, what's the situation, whether they have kids. And then another thing we recommended here was for your particular jurisdiction, listing any kind of requirements prior to their filing or petition, anything they might need to do. We do realize this will vary from jurisdiction to jurisdiction. We did not design this to fit every court. We designed this specifically as a model and as an example for courts to say, oh yeah, that makes sense for us, or I'm not sure if we could do this. So it would really, really be up to each court when they could implement this. It could be before filing, it could be online, it could be in person, it could be after filing when an answer comes back. It might be with a clerk at the window. They hand them the forms and hand them the survey as well and say, can you please fill this out so we know where you're at with your divorce or with your process. So it's really entirely up to each jurisdiction. But one thing that was key was, is there agreement on everything? Do they have agreement on their division of property and assets and liabilities? Do they have a parenting plan if there's kids? Have they agreed on custody and visitation, child support? Is there going to be spousal support? And then assuming the parties have reached everything in full agreement, then of course there's a lot of paperwork. Some parties might not even know what paperwork is required, but assuming they do, they've gone through it and filled out everything that is required for your court. And we just list, again, some examples. We know it will vary from court to court. But assuming all of this is taken care of, then we say, okay, this is a very stressful time. People are forgetful. They've got a lot going on. We just put in a reminder in here. Is everything signed? Is everything notarized? Is everything ready to go so you don't get to the court with your paperwork and realize, oh no, the other party didn't sign this document. So we just put that in there as a reminder. Assuming all of that is taken care of, then you have a party in front of you that is ready. They can go through the system and be done with this as quickly as your court allows. And this is where we recommend sort of what are your next steps? Is there a waiting period? Do we require mediation? Do both parties have to be at the final hearing? Does there have to be a final hearing? All of that we recommend listing right here so people know what to expect and they know how long it might take. We also suggested maybe putting things that people won't remember to do, like changing vehicle titles, changing their loans, changing just on DMV, stuff, anything like that, again, because it is a stressful time and people are trying to juggle so many things that things are bound to fall through the cracks. Now, of course, you are going to have people who say, I'm not sure, or no, I don't have this, or I need help, but I'm not sure with what. This is where the court needs to decide, okay, how can we help them? Can we keep these litigants in this early resolution group? And if so, how? And it could be something as simple as, I'm not sure how to fill out these forms. We can give you an example of that. Or, I don't have a parenting plan. We agree on what we want to do, but I don't know how to write this up. Okay, well, this is what a typical parenting plan might look like. Or, we want to do child support, but we have no idea what the calculation is. Maybe there could be a calculator. Again, this would be up to the court. It would be great if it could be something where it's online and they could just access everything, or if the court has a self-help center within the courthouse that the litigant can be directed to. But assuming it's something simple that your court can resolve fairly quickly, then you can actually say, I have your answer. Your paperwork's done. You can be done with this in however many months, and they can move to that next step process. You have a waiting period, you don't have a waiting period. The point is they can be resolved quickly, early, with as little court involvement as necessary. Of course, then you're going to have those who go, I have no idea, we don't agree on anything. Then they are the ones that you would direct to the next steps in the court and focus your time and your services on. And if they wanted to do mediation or some type of therapeutic services, that's the litigants that would move on to the next more detailed, thorough step. Of course, we did not want to ignore domestic violence, so we also recommended some potential safety screening questions that this could be done very early in the process when someone comes in. They could possibly fill out something and then they could be directed on where they need to go or get an emergency protective order or anything like that that might be necessary. Just a possible suggestion to add when doing this type of early pre-screening. So does anybody have any questions? Well, that again is up to the court. It could be, this could actually be like the Dutch survey where it's online and the litigant, when they're ready, they just go on and they take the survey and the forms could be linked. It just depends on what your capabilities are. It could be a situation when they come to the court to file the petition, they're handed their packet and this is included in it along with the forms and requirements. It could be a situation where they filed and once the answer comes in, then both parties are given this, because then you have confirmation from both parties that they agree versus just one. So it really would be up to the individual court and what your capabilities are. Yes, ma'am.
Is this process only voluntary for them, or in many courts do they mandate this?
Well, this again, it's not implemented. This is something we've designed the tool, so we're actually looking to pilot it. So it's not mandatory anywhere that I know of.
Is that what your expectation would be, though?
I would almost say yes, because it would be something where you are trying to determine which cases can go through the system very quickly, and if the litigants weren't willing to fill this out and give you the information you need, you would not be able to do that.
What about in Holland? Do they require the parties to do this before they come to the court, or you don't know?
I don't think so. I think this is just a self-help service that they can access and use as they wish. Okay, well, so the next part of our presentation is to hear what courts are actually doing in real life.
Okay. Again, my name is Deborah Denny. I'm from Lincoln, Nebraska. I'm with the State Court Administrator's Office in Dispute Resolution and Special Court Projects. And one of the special court projects that I'm working on is I'm working with the Chief Justice's leadership group who has a Parenting Act committee to look at high-performance domestic relations courts and triage. But I came up through the mediation arena. And so that's why I chose this cartoon, where the person's walking down the court hallway and wondering, do I go in the facilitation door? Do I go in the mediation door? Negotiation or arbitration? And while they're looking up at the doors, they're going to step into this pit called litigation. And my preference over the many years when I practiced law, I did domestic relations and child welfare and juvenile justice, all of those family kind of arenas. And also ran a nonprofit mediation center in Northeast Nebraska. I'm really big into thinking about systemic change to figure out ways to make the justice system more accessible to families so that they don't fall in the pit of the traditional adversarial process. And so that's why I was really fascinated with this whole idea of triage and differentiated case management in domestic relations cases. And I'd like to know, with a show of hands, how many here does your local trial court do differentiated case management for domestic relations cases? Could you raise your hand? Okay, so about 25% of you. And how many here, are you familiar with the distinction between the word tiered and triage? It was really helpful for me to have that concept of tiered services versus triage services brought out. And tiered, T-I-E-R-E-D, of course there are tiers when you go through a divorce or custody, but this is T-I-E-R-E-D. You know, if you can imagine a set of steps, that you're going up a set of steps, and at the end of a long set of stairs you finally reach your decree. And in order to get up to your decree, you do one kind of procedure at a time. In a typical custody or dissolution, you start with your filing, you file the petition, you wait for the answer, then you might have a preliminary hearing, a temporary, then you might be required to go to mandatory education, then next you might be required to go to mandatory mediation, and then you might have some discovery, and then finally you make it to the final decree. And so that is kind of a simplified version of tiers, going up those steps. Triage, on the other hand, is, as Shannon was talking earlier, and Brian, it's a way of sorting the parties that come to the court. So instead of, you know, in the justice system, we try to, you know, have equal access to justice, due process, and so traditionally our courts have been set up to be pretty uniform in how people go through this tiered process. And of course, the whole idea of parenting education and mediation and those other resources, we're in recognition that we're trying to make the courts more person-friendly and less adversarial. You know, when we went to no-fault divorce back in the early 70s, that was part of the whole history of trying to separate this adversarial nature to more cooperative. But all in all, when we think about triage and sorting, it's shifting, and I like to liken it to that bell curve. When you think of the bell curve of people that we see that are needing custody and dissolution orders, there's the easy people on the front end, the people who can come in and they have all of their paperwork done, they've decided what they want to do with their kids and their property, et cetera. And then at the other end of the bell curve, those are the tough cases, that 15% that comes back time after time after time after time after time. And so thinking about, the way I like to think about the triage or differentiated case management in domestic relations is recognizing that in some ways we can think about it as a problem-solving court, right? You know, that we're looking at this civil court process where if people at the tough end, that 15% of high conflict domestic abuse, substance abuse, mental health, that where there's a lot of pressure on the court process for post-decree custody battles, that, you know, parenting coordinators get involved, that the courts can put more of their resources over there and that hard 15%. And then if we can so-called offload the easy cases early on, it'll make the customers, the consumers more happy, it'll take less resources and less court time and move people through the system to achieve what they want. So love the concept, but how do we inform and educate our colleagues back in our states to say we want to go down this road and shift from a tiered to more of a triage process. And that's what I'm going to talk about in Nebraska. Nebraska domestic relations, we still have, you know, we're in the Midwest. We're kind of the last people from the coast to do things differently. So in a good way, we learn from other people's mistakes and other people's approaches. And one of the things that drives me crazy in Nebraska is when I practiced law back in the early 80s, the terminology was petitioner and respondent, and somebody got a great idea that domestic relations should be plaintiff and defendant. And to me, that's obnoxious, that, you know, that you're getting a divorce or you have a custody thing and somebody is a defendant. So for me, one of the goals that I'd love to see is to change the language in this process. In 2007, we amended our Parenting Act where we required a parenting plan. I know that might be later than many of your other jurisdictions, but at long last, we required that. We do require mediation prior to contested custody. We do require parenting education. We have mandatory parenting information brochures, and for domestic abuse and high conflict cases, we have a specialized ADR process. So right now, I would say Nebraska has a fairly tiered process, that's step by step by step by step. In 2011, however, we're just tiptoeing into what I would call more of a differentiated process. Statutorily, the legislature waived the final hearing, so the judges can waive that final hearing if all the paperwork is in. How many else out there, how many of your jurisdictions waive a final hearing? A few hands gone up. But, you know, it's like, oh my goodness, you're not going to have a hearing? And yet if people have filed all the proper documents and they can go forward. So that's a baby step in an incremental way to start going to more of a triage process. In 2011, we started an evaluation of our Parenting Act. We're just finalizing it to see if the Act's being implemented appropriately, and is it reducing children's exposure to parental conflict. That has set the stage for our judges, our lawyers, our court staff to start thinking differently about domestic relations and how it's being done, and truly to recognize that our justice system, one of our goals in addition to addressing court resources, is to look at what's the impact of the judicial system on the children's exposure to parental conflict. And so, how many here have studied the change process or kind of know about it? You know, you can have a good idea, but how do we help other people come along with the idea that we do want to change how our system is working? I would, in the work that I've done in organizational conflict design, what you see is the tiered process, the education, the mediation, the specialized ADR, the temporary hearings. Those are all kind of incremental, distinct grassroots way of dealing with issues. But what the triage and differentiated case management is trying to do is it's trying to redesign the whole system process. How does the court do its business in terms of domestic relations? So if you think again about problem-solving courts and how they've changed how the court does its business in problem-solving courts, it's kind of, in my opinion, a parallel to how does the court change its business process to work with domestic relations. So what have we done in Nebraska? Well, because I was a part of this National Center kind of mini think tank in Denver in February of 2014, where the High Performance Domestic Relations Court and the Triage project was started off that Brian and Shannon talked about. When I came back to Nebraska, I suggested to Chief Justice Heavican, could we invite the National Center to your annual Supreme Court Leadership Conference to talk about triage and differentiated case management? And so Alicia Davis from Denver came out and did a presentation to a group of about 40 trial court judges and appellate court judges on this concept. To me, that's kind of dipping our toe in the water to start introducing an idea. So that was a year ago. This year, at the Chief Justice's leadership meeting, I was part of the planning process, and we polled all of our judicial leaders across the state and asked them, what do you see are the emerging issues that your court is wrestling with at the trial court level? And we fleshed out about 30 emerging issues. And on the high end of those 30, we picked the top 6. And one of the top 6 was custody, parenting, domestic relations. So because of that, at the Chief Justice's leadership meeting back in May, we have now a new task force working this year, and the goal is to accomplish a concrete step toward moving toward a high-performance domestic relations court. And that's what I'm here to talk with you about, is to give you an example of a state, and we're a fairly unified court system in Nebraska. We do have 12 districts. We have about 55 district court judges, which are over the domestic relations. Of course, each judge has their own court and do things their own way. However, we try to have a nice balance of local control and some statewide uniformity. But one of our goals in this new Parenting Act subcommittee is to do another incremental step toward more of a triage, which is right now, to get a divorce in Nebraska, you have to wait 60 days after filing and service. How many states have a waiting period between filing and final decree? A lot of you. We were privileged to have Judge Kevin Burke at this leadership meeting from Hennepin County in Minnesota. And he talked about in his court, they got rid of the waiting period, and if people come to him at the preliminary meeting, he doesn't have his robes on, he's just sitting down meeting with them within 3 weeks of filing and service. And he basically does a verbal triage with the parties. And if they have all the paperwork and decisions together, they can go downstairs and get the decree that afternoon. It's that simple. I thought that sounded pretty awesome. So I'm just going to stop with that and transition over to my friend Serpy, who has a lot of on-the-ground triage activity in Cuyahoga County, Ohio.
I'm Serpy Ergen. I'm a magistrate in Cuyahoga County, which is in Ohio. Been there for 29 years, and I have seen a lot of changes in 29 years over how domestic relations court is operating. You know, we've seen changes in pro se litigants and all kinds of services. The court's becoming sort of an umbrella for services that are provided within the court, and we're not doing things business as usual. You know, where it was an adversary system where the court basically follows what lawyers are basically dictating to the court to do, and the judge is an impassive, impartial observer who just steps in at the end. We are now being a very proactive court, and so we were really excited about this concept of triage, even though we didn't even really know what the word triage was. We just kind of realized that we were doing it already. So what is triage? You know, one of the things, really all it is just a common sense thing of sorting cases, right? In the past, cases would come in and you would just put it on the next person available's docket, and they would just handle it like every other case, and it would just go through the end. And we really didn't worry very much about customer service. We didn't think about, you know, how it was going to be. It was just going to be processing the cases or whatever and going to the end. But now there's been a lot of research about divorce and the effect of conflict on kids, and, you know, how the process is working. And I think that we're all aware, you know, if you work in the system, that the public is not happy with the courts, and they're particularly not happy with domestic relations courts. Have any of you guys seen that movie Divorce Court that came out sometime in the last year? I don't know if you know that. It is awful. It's you know, it's basically just terrible about what people perceive about the court system and how expensive it is and how much delay it is, and how you know, damaging it is to families as they're going through it. So we have to do something in order to improve people's experiences in the court system. And so one of these ways that we can do it is through triage. Triage, you know, it's, you know, we're borrowing that word for the medical community, but really it's an aggressive and proactive form of case management. That's all it is case management. We're sorting cases, you know, according to whatever, you know, decision points we can find, variables that we can use to sort cases, and we're trying to deal with them as they're going along. And it is important to link the parties with the services and the programs and the information. Maybe it's just information that they need. They are going through a system, many of them are pro se, they don't know how the system's going to work. They need some help, but they're having trouble even articulating what kind of help that they need. They don't even know who to ask, where to go to, or anything. So, and what we do currently, or what we've always done, is put them into this system where we're giving them all this due process. That's what we're about as courts, right? We provide due process, we make sure that the process is fair, but we overdose people. I mean, we give them this, we give them this, we give them this, we make them come back down to court over and over. They take off time from work, they have to pay for parking, they have to pay for childcare, they come down to court, they don't know what they're doing there, they don't know why they had to come in the first place, and they're going through this waiting period, and for what? Why are we making them do that? So one of the things that I've always been interested in is therapeutic jurisprudence. You know, the idea that our laws, our policies, our programs, our procedures, our rules shouldn't hurt people, they should help people. I mean, just like in medicine, the treatment provider who's taking care of the patient shouldn't be harming the patient, right? So we're like that. We're the justice system. In trying to administer justice, we shouldn't be hurting people. We should actually be trying to help them. And if we actually looked at, you know, how our policies, how our laws, our procedures impact on people that way, whether it has a detrimental effect or if it has a beneficial effect, we might find that, you know, we really could do things a little bit better for people. And I think it's important for us as domestic relations court to kind of take the lead on this, because most people who are involved in this in the justice system, they're coming in, their exposure to it is through domestic relations court. They might have a traffic case here and there, but they're not going to have a tort case. They're not necessarily going to have a criminal case, but they surely are going to have a divorce case at some point, or some member of their family. And that's what their perception of the legal system is through the way that they are treated in the divorce process. So, the idea is that the court has to pay attention early to these cases. We can't just put them on a conveyor belt and, as Brian was saying, you know, a prescribed series of steps that we're going to put them through. We have to teach each case individually in order to do individual justice in individual cases. So the National Center's approach at looking at this when we met in Denver and tried to figure out, you know, how should we conceive this project, was that we should try to take out, as Shannon said, the cases where the people pretty much have an agreement or very close to getting an agreement, and how could we kind of pick them off and steer them through and get them through this process in an expedited way. And so we came up with this tool, which is, as Shannon said, it's very flexible. It's not meant to be the be-all, end-all of everything. It's probably should be considered a work in progress, because you're going to adapt it in your courts and maybe create a series of questions that's going to work for you. But it's a way of sort of thinking about how we would go about doing this. So the National Center's approach was look at to see whether do you have an agreement on all the issues, and do you have all your necessary paperwork done, because people can have agreement but they have no idea how to actually put it in a shared parenting plan, right? Or they just need a form separation agreement, or they have a pretty good idea what the child support should be, but they have no idea how to compute it or have access to the actual guidelines. And in my state of all things, we don't have the child support guidelines available. It's all proprietary software, and no one can get it unless you go to a lawyer or you pay for a company to do it for you, which is, to me, is just crazy. So the idea was that we need to link people to these services, and you know that pretty much is the hallmark, though, of Triage, is that you have to have services to link people to, you know, and the services could be really something broad. It could be plain old information, about the divorce process. It could be information about getting court forms or how to fill out court forms. It could be a link to legal aid. It could be a link to attorneys who do unbundled legal services. It could be links to mediators who are outside of the court or mediators who are in court. It could be a pro se clinic where they will help them work through it. It could be an accountant who's willing to take some time and show you what the impact of a divorce would be on you financially. It's all kinds of different things, but how do we link people to these services and get them even to be thinking about how they would ask these questions? So our court, I wanted to tell you a little bit the way our court approaches it. Ohio is a really highly decentralized state. We have 88 counties. We don't have an AOC. We don't have any consistency or uniformity in the way one court does it, or even the way an individual judge might do it within the same court. It's kind of all over the place. And that sounds like it's a bad thing, but I have to say that in some ways it's a good thing, because we sort of have the opportunity to be able to make a change and try it, and if it doesn't work, we can be creative and we can change it pretty easily, as opposed to my impression from being here is that, if you have to do it as a statewide thing coming down from the top, it's hard to make those changes. And as somebody mentioned in another training yesterday, that if the decisions are wrong, then the whole state's doing it wrong. So it's an opportunity, I guess, if you're decentralized, to kind of be more nimble and make the changes as you're going along. And so we have the capability of doing that. So the Cuyahoga DR Court is the largest DR court in Ohio. We have 5 elected judges and we have 19 full-time magistrates. We process about 8,200 case types a year. That's marriage terminations, custody, the ones that are counted, and we probably do about 20,000 motions a year. So Columbus might be overtaking us pretty soon, but we are a pretty high volume court. In our court, we assign cases to 4 separate dockets, and I gave you the paperwork out there because it's hard to see on that screen, but that was just to kind of give you an idea. So we have lots of people working at the court, and so when the cases come in, they're going to be assigned either to a marriage termination docket, or if it's post-decree, it would be a property division enforcement docket, or a custody or visitation, modification or enforcement, support, those are 4D magistrates, and then DV. So once the case is filed, there's a case designation sheet that lets us know right away what type of case it is, and then it'll go down those tracks to the appropriate people who will handle it. In terms of how our court is oriented, we have a heavy use of magistrates, which I'm getting the impression from being here that is something pretty different from other states. Magistrates are court employees in Ohio. They are career professionals. They have all the qualifications that judges do, and many of them, in fact, will run for judge later. They are held to the same standards of conduct that all judges are held to, and they do the bulk of the work. I mean, if you have, like I said, in our court, 19 magistrates and 5 judges, you can see that the workload is heavily geared towards the magistrates doing that kind of work. But the thing with the differentiated dockets is that the people who are handling that work, they get to be expert at what they're doing. They are they know those issues. If you're on the custody docket, they know those issues right away. If you're on the support docket, they understand all the issues that go along with calculating support and contempt issues and things like that. And so it's very, you have a level of expertise that you wouldn't get when you use differentiated case management than if you had to be sort of a jack of all trades and like a practitioner that's doing kind of everything, and then you only understand a little bit about everything as opposed to being an expert in it. We have a really strong focus on meeting time guidelines in our court and ensuring that court events are meaningful. We are interested in resolving cases in the shortest period of time with the fewest number of hearings possible, but we want those hearings to be meaningful. So we want to make sure that each hearing is scheduled for the appropriate amount of time for that hearing, and that the time in between hearings, the median time in between hearings, is exactly what it's needed. And I was at another training recently where they were talking about the time in between those hearings, and that it depends on local culture. Somebody comes in and asks that you need to do a reset, and it should be it's automatically 30 days or it's automatically 60 days. We're not like that. If the case needs to be continued because we need to get some tax returns, well, we can do that in 7 days. You're back in 7 days. We're not going to spend 60 days waiting for you to get the tax return or whatever to come back. So we're trying to boil it down to the fewest number of hearings because we're not interested in dragging people back to court again over and over. Their time is valuable and our time is valuable. And once we put this in place, we found that we're really able to get good clearance rates. We have good time to disposition, our age of active pending caseload. And what it does is, when you get resolved cases more quickly, you have all kinds of free time to work on the cases that really do need the work. And you have openings in your docket to have cases come back quickly. It's not like, well, the first available date is 6 months from now or 3 months from now. It's a very effective thing. So we have expedited tracks, and we have an ordinary track, and then we have complex tracks. And really the difference between the complex tracks is that you might have to have more hearings in between after the second appearance, because there's just some cases that are really complicated and you have to have more time to do those things, or there are appraisals and things being done that for reasons beyond anybody's control that just didn't get done in the right time. Yes?
Quick question.
Sure.
You may have said this. The magistrates, are they located on certain tracks or certain places of the track?
The magistrates, here's the thing, in Ohio, magistrates can handle the case from the beginning to end. So we don't do just preliminary matters or this discovery, things like that. We get the case from the very beginning and we go to the end. I'm not saying that in all courts that they will do that, but in our court we do that. So I will get the case from the beginning, and if it has to go to trial, I'll try the case and I'll write the findings of fact and conclusions of law. And it's very effective because there's no one that knows more about that case than that one person, as opposed to sort of piecemealing it out for people here and there, so that this person's doing this and this person's doing that. And there's a real rapport that's developed between the hearing officer and the people because it's the same person. They get a trust level with us, so that when I say, I think that might be something that you should seriously consider, they get it, right? As opposed to, when am I going to see the judge? And I only see the judge at the end, and they're sitting way high on the bench, and I don't know him, and he doesn't know me. It's very hands-on. And so what we do, one of the things I wanted to get back to was the sorting of the cases. So one way that we sort cases is at filing time. And we have this in Ohio, what I think is a great thing is that there's a statutory filing called a dissolution, which is separate from divorce. It's a marriage termination, but it's done by the parties both petitioning to the court asking to terminate their marriage. And when they file that, they have to have the separation agreement and all the paperwork done at the time of filing. So once that case comes in and it's designated as a dissolution, that's expedited. It's going to be, by statute, it has to be done between 30 and 90 days, but we will always schedule it on the 31st day, and unless something goes wrong and they need a continuance. So those cases are done very quickly, and we also have a statute in Ohio that says that if dissolutions are the result of a collaborative law process, they can get their case done even before 30 days. They could even get it done 10 days after filing. So that is a great way of differentiating and not just putting them on the track to come down to court over and over just to find that out, because we know that in advance. And I would think that, does anybody have such a thing in your jurisdiction to, or is it all just filing for divorce? No. So you do? Oh, yes, you're in Columbus. There you go. But I would think that if you could explore that in your jurisdictions, that wouldn't be that hard of a thing maybe to get, to sort of have an expedited track so that you could, look into changing the legislation to create such a creature so that it isn't all filing for divorce. Another way of differentiating cases is obviously answer date. If no answer comes in, so we have, when the case comes in, we have somebody who's assigned to look at the case to see if there's an answer coming in. If no answer comes in, then we will set it for a final hearing uncontested 42 days after service, which is the earliest time under the statute that we could grant it. That's expedited. It is done. People are on their way. Then you have the other cases where people have filed an answer, or an answer and counterclaim, and then you're sort of differentiating between, is it ordinary or is it complex? How complex is this? How many parties are involved? Is there property? Is the property located outside of the country? Are there high conflict issues going on, special needs, things like that in this case? And so those cases may take more hearings. But basically, if you look at that chart, under the first one, the divorce, you're going to have a case management conference, and I'm even having trouble reading it, but I think it's 60 to 90 days or whatever, and then you will have a second appearance, which is basically, yes, a report out, and if you have to make additional orders, and then you're going to have the third one, which would be a final pretrial or settlement conference, and then it's trial, and it works pretty well. So that's our form of differentiated case management. One of the things that I think is really important when I was focusing on being aggressive case management is that the hearing officer has to be really, really actively involved. So what I was talking about before has to do more with the screening tool and trying to differentiate the cases between the ones that have an agreement versus the ones that are contested and they're going to really need some more care and attention by the court. And so at that very first hearing, the magistrate, we will set it for like an hour. We don't do 10-minute status calls to find out that it's contested or not contested. We spend about an hour with the people really going through the issues and explaining what the pros and cons are of appointing a guardian ad litem or going to mediation or doing a forensic custody evaluation and all those things. And as a result of that, we learn a lot about the case, and then we make referrals for services. And we don't, basically the magistrate or the judge is making a clinical assessment of what's going on. It's not using a tool or anything like that to do it. It's just making, after having a really informed discussion where the parties are always in the room with the attorney so that everybody's doing it together and we're all rolling up our sleeves on this, then the court will make a clinical assessment and say, I think you should go to mediation at this point, or maybe we need to settle this, or maybe we need to do a brief focused evaluation rather than a full-blown custodial evaluation, or maybe we need to do a substance abuse assessment, but we don't need to do all this other stuff, or maybe you need a parenting education class, but you don't necessarily, it doesn't have to be skills-based, it just needs to be a parenting education class that has to do with the effect of conflict on kids, and the effect of divorce on kids. And so that's where we kind of focus on it. So I just kind of wanted to leave you with that. It works for us. I think it could work for you, but it's not going to be the same way that we do it. I mean, you have to figure out how you could adapt this approach to your locality. I think it's a holistic approach. I think it could really reap benefits for you, not just for the parties, because as I said, I think it's better for them, but for you, because you will have more time to focus on the cases that you really need to do, and you'll be able to use the resources, which we know are scarce for everybody. You'll be able to use those for the cases that really, really need it, and not just putting people through the steps and using up your own time on things that are really not very meaningful. So with that, I mean, I could probably talk for hours about this stuff, but I need to let you guys ask some questions. Yes?
I guess I have a question for both your project and the Nebraska project. It sounds like you both implemented some kind of triage. You seem to think you're going to save time and resources, but at the end of the day, are you collecting information? How are you evaluating it? Do you really know whether you're saving any time or
Okay.
any money, or is it just something that everybody's got a good feeling about, and so you're charging ahead with it?
Okay, so I think that's an excellent question, because we all want to be data driven, and I'm not saying that, and I'm going to kind of ask our researchers here to tell us, but I don't know that there is a ton of empirical evidence on this that it necessarily works, okay? I think it's really kind of new, and not too many places are doing it, and I think it's a little bit early to say that it's not going to work or it is going to work, but I think at this point we really almost don't have any choice to kind of go ahead and try it and see. And I would just say anecdotally it's working for us.
Yeah, your gut reaction is
Yes.
it is working.
Yes, differentiated case management works, and triage works too, at least from my own personal experience. I don't know if you guys wanted to add anything to that.
Yeah, in the electronic materials that you have, there's a bibliography, a very short bibliography on triage and differentiated case management. And there has not been a research empirical study on it yet. And so this is all newer. Nebraska, as I said, is still in the process of deciding, yes, we want to go this direction, so that's step one. Step two is when we start going that direction, is there a way that we can track data to give us that empirical information? So for example, Nebraska's doing this evaluation of our Parenting Act and the changes that happened in '07. What we have seen is that it has decreased case management processing time from start to finish because of the act, and so we've collected that data. We studied 600 dissolution cases over a 10-year period and collected over 183 data points on each one. It's that kind of evaluation data collection that I think is fairly new for courts to do. So it's something for all of us to think about.
In either of your cases, did you have to add staff to do this, or reduce staff, or you just reallocated resources?
For us, didn't change any staff, because actually we're already doing it. Like I said, you know, our magistrates do it. We make a clinical assessment. But what we are going to do, and I think this went back to a question that somebody else earlier, it says who's doing this and when are you doing this? The way to do this, I think, it can be multiple ways. One way to do it, and I think we're going to do this, is to put it on our website. Not exactly like that, but to sort of create like a TurboTax type of questions with skip logic that will get them thinking even before they even file, when they're just considering filing, that will take them through the steps and consider, do you have this, do you have this, do you need this, do you need help with this, and provide them those linkages before the court even gets involved. Another way to do it would be at the time that they file, to have them, you know, to do that there. Another way to do it, I guess you could have a case manager or somebody assigned and make them both come down to court later and then administer it to them, but that would require another step in the process and maybe adding somebody else to do it. Another way to do it would be maybe right before that first court event, so that the magistrate maybe would have less time, or the judge does this too on their cases, but they would spend less time actually asking the questions. They could have the questionnaire, you know, maybe kind of filled out ahead of time, and then go into the hearing armed with a little bit more knowledge about what it is that these people need. But again, I mean, the idea behind this is that, you know, there are people who are in need of surgery, And when we put them on that conveyor belt, we're basically taking their temperature over and over when they need immediate surgery. And then there are other people who, you know, need a Band-Aid, and we're, you know, we're doing surgery on those people, and they don't need that, right? So, you know, it's just a way of really being proactive and looking at these cases and really being individual about these cases, as opposed to just the standard, let's do business as usual. So, yes.
So you said you had 19 general magistrates in here,
Yes.
and you have 5 judges.
Yes.
And the magistrates, they do cases from the beginning to the end. What cases would actually be referred to a regular judge then? What does the regular judge do?
All the cases our judges are elected, and all the cases are actually assigned to the judge. But when the judge gets the case, the judge routes them to who they want to hear, right? So our judges don't like to do post-decree, and they don't like to do the support cases. They like to do the marriage termination cases. And so, so they will divide up the marriage termination cases between a trial magistrate, not necessarily a good use of the word, but they'll divide up the cases with a person who's assigned specifically to work for them, right? Then the post-decree docket is handled by me and 5 other magistrates. The support docket, post-decree support docket, is handled by 7 magistrates, and the DV docket, which is really our growth industry, is handled by 2 magistrates who are just do only that. And so the judges, but one of the things, the magistrates will make, you know, they'll file recommendations and things, but the judge has to independently review every one of them. I mean, they don't just rubber stamp them. They do review them. But as I said, you know, these people are career professionals, and they know what they're doing. So unless something was really odd, you know, probably 9 times out of 10, it's or even more than that, they're going to just, you know, they'll review objections as an objection process, but they're going to most likely overrule any objections to the magistrate's recommended decision. So.
Okay, so I know our time is almost up. I just wanted to direct you guys to the High Performance Domestic or Divorce Case Triage website that has some information about the project. It also has a link to the final report and some of the resources. Included in your materials was also a list of resources that you could use to just see some of the stuff that we reviewed when we were doing this process. Excuse me. And if there's any questions or you want some more information, of course, feel free to contact any of the 4 of us. We could certainly direct you to all the stuff that we used. And we hope at some point to get the final paper published as an article. So hopefully that'll be a resource as well. Okay, did you guys have any other questions? Yes.
Do parties have opt-out options? Like you suggest some of those menu, but the parties say, no, I don't want to do this. They can do that or not in practice?
Well, I think it depends, again, on how you're going to implement this type of pre-screening, because Deborah and Serpy both gave really excellent examples. They have their mandated fast track that if everything's in order, they're put on this track in Ohio and they can go and be done with it. And then Deborah was giving that great example where the judge actually calls them in and sort of does an interview with them, and if everything's in order, then they can get their degree right away, which is amazing. So that, I would imagine, it would just be what the court could do. It would be up to you guys if you think it would be worth making it mandatory or letting them opt out.
So Ohio case, when the case comes with custody, you do dissolution first and then deal with custody later?
No,
okay.
no. I'm talking about post-decree, continuing jurisdiction where they want to modify or you know, change a custody order or a parenting time order. That's what I mean when I say post-decree custody docket. Or they're coming in afterwards.
Oh, okay.
Yes.
So when they come under those 2 issues together, I have a kid, I want a divorce, then how would you put the case into?
It goes under the marriage termination because, you know, whoever's handling that divorce case is going to handle all the issues in that case. So it would be, you know, here it would be one of these ones up at the top.
It doesn't say anything about the custody though. I'm just really confused about this chart because some as if the case comes with those 2 issues, you do.
If there's just plain custody.
Yeah.
In Norfolk, we do custody first. So the parents that doesn't
Mm.
use kid issue as a hostage to the divorce.
If we can get them to resolve the custody issue while the divorce is pending, we will get that piece done as soon as possible, right? So we don't wait, but we don't technically grant a divorce without doing all the issues that have to be done, which is property
Okay.
division, spousal, child support, and child custody and parenting time.
Anything else? Okay, well, thank you guys for coming.